Subcommittee will come to order. Good morning. Welcome back, Mr. Friel. Good to see you again as always. Ms. Van Haren, how are you?
Doing well.
I like to mix things up a little bit.
Great.
Today we'll be taking a closer look at the VA's Fiduciary Program. The Fiduciary Program the Fiduciary Program at VA is responsible for appointing and overseeing the men and women who assist veterans and other beneficiaries that are unable to manage their VA benefits on their own. Over 67,000 veterans use fiduciaries. The last time the committee looked at the program was in 2015. I believe it's time that we take another look at this program to ensure it's meeting the needs of today's veterans community. In fiscal year 2022, the program oversaw $2.6 billion in benefits. A program this size requires effective oversight to ensure that beneficiaries are being taken care of, especially because these beneficiaries are typically our nation's most vulnerable veterans. The subcommittee has also heard directly from VA regional offices employees who are directly responsible for the oversight of the fiduciaries and beneficiaries about potential instances of fraud and misuse in the program. A fiduciary should be using a beneficiary's VA funds for the beneficiary's care or the care of the dependents, and VA should be doing a better job of preventing, investigating, and remedying these instances of fraud and misuse to protect veterans first and foremost. That being said, some of these instances are not the result of malicious or on the part of fiduciaries, but simply because Veterans Affairs has not provided family members acting as fiduciaries proper access to support resources they need to properly manage the beneficiary's benefits. Frankly, the program seems somewhat disorganized, and we need to hear from the VA about how they're going to fix it. To that end, we will be hearing from our OIG on the recommendations on how VA can better oversee the fiduciary program, as well as updates from VA on what steps they're taking to do so. Again, I would like to thank everyone for being here today. I'm looking forward to our conversations about what we can do to prevent the misuse of veterans' hard-earned benefits, enhance the VA fiduciary program, and ensure the misuse funds are returned to the veterans they earned in a timely way. With that, I yield to the Ranking Member Pappas for opening statement.
Well, thank you, Mr. Chairman, and I appreciate you holding this hearing, and thank you to our panelists for joining. VA's fiduciary program has a long history dating back to its establishment in the 1930s. The program provides oversight and protection of VA's most vulnerable beneficiaries. These are veterans and survivors who are unable to manage their VA benefits or their own affairs. The fiduciary program is incredibly important to our nation's veterans and their families. Fiduciaries are trusted to manage VA benefits in the best interests of these beneficiaries. Accordingly, Pension and Fiduciary Services oversight of VA-appointed fiduciaries to ensure the beneficiaries' needs are met is absolutely vital. However, over the years, the program has faced persistent challenges, including instances where fiduciaries entrusted with veterans' finances have breached their duty. This has led to financial hardship and distress for some beneficiaries, highlighting the need for robust oversight and accountability within the program. As ranking member of the subcommittee, it's my job to ensure that the fiduciary program is taking every measure and has the support necessary to fully safeguard beneficiaries' assets. At today's hearing, we'll seek to assess whether further congressional action is needed to ensure that our most vulnerable veterans are afforded the highest level of protection possible. Recently, OIG has issued several reports on the fiduciary program. These underscore the benefits of the program, but they also point out deficiencies, wait times, and misuse of benefits that have hampered effective oversight of the program. For example, an OIG report published in 2021 brings to light issues of timeliness in VBA's fiduciary program operations. Delays in determinations and reimbursements of misused funds pose a significant challenge. To address this, the OIG recommends that VA implements streamlined procedures, enhanced training, and advanced tracking mechanisms. These measures are essential for bolstering the program efficacy and safeguarding the financial interests of veterans. A second report published in 2023 highlights a critical concern within the program, the timely return of funds belonging to deceased beneficiaries. The issue at hand underscores the necessity for rigorous verification processes and suggests that improved protocols and technology integration can also enhance the program's oversight, ensuring a more efficient and responsible handling of beneficiaries' finances. So these two reports are concerning to me. I look forward to hearing more about VA's progress toward implementing the OIG's recommendations. And further, my staff has heard from numerous Fiduciary Hub employees about insufficient authority to ensure beneficiaries are receiving their benefits or are properly being taken care of. VA employees also have noted that guidelines within the program are too broad and are left up to interpretation, making it difficult for these employees to do their jobs. The program is particularly vulnerable to fraud and abuse. It's VA's job to prevent that to the extent possible, but it should be noted that the problems around fraud and misuse are not representative of all fiduciaries. The vast majority of fiduciaries are doing an honorable and honest job taking care of our veterans who can't handle their affairs, many of whom are family members themselves. But the need for robust oversight is clear and can't be overstated. So I'm interested in hearing more from our witnesses about the present challenges and concerns facing this program, how we might work together to address them, especially how to improve the reimbursement of beneficiaries when fiduciaries misuse VA funds. So we must leave here today with a better understanding of where VA currently stands in the management of this program for our most vulnerable veterans and what further assistance Congress can provide in these efforts. So to that end, Mr. Chairman, I appreciate you holding this hearing, and I yield back my time.
Thank you, Mr. Pappas. Our witnesses today, Mr. Friel from the Veterans Affairs, the Deputy Director of Pensions and Fiduciary Services. We have with us today Ms. Van Haren. Did I say that correctly, ma'am? Who is the Director of Claims and Fiduciary Divisions for the Office of Audits and Evaluations from the Office of Inspector General. Would you both please rise? I ask the witnesses on our first panel to stand physically and raise your right hand. Do you solemnly swear that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth, so help you God? You may be seated. Thank you, and let the record reflect that the witnesses have answered in the affirmative. Thank you all again for being here today. Mr. Friel, you are now recognized for 5 minutes to deliver your opening statement.
Chairman Luttrell, Ranking Member Pappas, and distinguished members of the subcommittee, thank you for inviting me here today to discuss the Department of Veterans Affairs Fiduciary Program and the vital role we serve in protecting vulnerable beneficiaries. Mr. Smith sends his regrets that he is unable to attend today. In August 2023, Legal Instrument Examiner Terry Smith of the Salt Lake Regional Office received a call from a veteran in our fiduciary program. Her mother was her appointed fiduciary but was in the hospital with a poor prognosis. The veteran requested funds to visit her mother before she passed. Mr. Smith spoke to Field Examiner Roland Parrish.
I'm sorry, Mr. Friel, can you move closer to the microphone? We can barely hear you.
Sir.
Thank you, sorry.
You're welcome, sir. The veteran requested funds to visit her mother before she passed. Mr. Smith spoke to Field Examiner Roland Parrish, who personally drove to the bank with a fiduciary agreement to withdraw funds so that she could be with her mother in her final hour. Concurrently, Salt Lake City staff began the successful fiduciary appointment process to coordinate uninterrupted benefit payments to the veteran through her time of need. Mr. Smith and Mr. Parrish demonstrated through action the highest values of VA. Veterans are at the heart of everything we do. These employees' commitment and advocacy help to offer the veteran peace and support in time of need and ensure her dignity going forward through prompt appointment of a new fiduciary. I am proud to represent them and more than 1,200 VBA staff who work every day to protect our most vulnerable veterans and survivors. With values demonstrated by our Salt Lake City Fiduciary Hub in mind, I'd like to describe key tenets of the Fiduciary Program, whose mission is to protect the over 104,000 beneficiaries who are unable to manage their VA benefits because of injury, disease, infirmities of age, or being under the age of majority. The decision to appoint other person to manage a beneficiary's funds is never taken lightly. VA always presumes competency unless clear and convincing evidence states otherwise. A potential fiduciary must be qualified, willing to serve, and the appointment must serve the beneficiary's interest. VA thoroughly investigates a proposed fiduciary's criminal background and credit history to assess suitability. VA will also assess the input and needs of the beneficiary and their dependents. There are approximately 83,000 fiduciaries who are responsible for ensuring that the beneficiary funds are used for the sole purpose of meeting the needs, security, and comfort of the beneficiary and their dependents. Except in certain circumstances, fiduciaries are required to submit either an annual accounting or a biannual fund usage report. VA investigates any credible allegation or finding of misuse of VA funds swiftly to protect all beneficiaries. VA will remove a fiduciary from service and appoint a successor if the allegation of misuse is substantiated. If fiduciary refuses to respond to VA's auditing requirements, is unwilling to serve, or is found unfit through annual criminal background investigations. In fiscal year 2022, VA conducted more than 2,000 misuse investigations and removed 817 fiduciaries. VA referred 25 cases to the Office of Inspector General for investigation, of which 15 resulted in conviction with more than $1.7 million in restitution ordered to the beneficiaries. Since the establishment of the Independent Pension and Fiduciary Service in 2011, VA consolidated all fiduciary activities to 6 regional fiduciary hubs, revised its regulations to align VA policy with current law, clarified the rights of beneficiaries, and refined the roles that VA and fiduciaries play to ensure that VA monetary benefits are managed in the best interest of the beneficiaries. In fiscal year 2021, the Fiduciary Program implemented a comprehensive plan to reduce unnecessary intrusiveness in the lives of VA beneficiaries and their families while also improving oversight. For example, VA streamlined the interview and investigation process to improve VA's fiduciary appointment timeliness and access to benefits. As of August 31st, 2023, VA reduced the average days awaiting an initial appointment field exam from 38 days at the end of fiscal year 2020 to 26 days as of August 31st, 2023. VA also migrated from a legacy IT system to the Veterans Benefit Management System, allowing for more effective delivery of fiduciary program services, with more improvements planned. Mr. Chairman, this concludes my statement. Thank you for the opportunity to appear before you today to discuss these valuable services to veterans and their survivors. I'm prepared to respond to any questions you or other members of the subcommittee may have.
Thank you, Mr. Friel. The written statement, Mr. Friel, will be entered into the hearing record. Ms. Van Haren, you are now recognized for 5 minutes to deliver your opening statement.
Thank you. Good morning, Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee. Thank you for the opportunity to discuss the OIG's oversight of VBA's fiduciary program. Given VA's commitment to serving vulnerable veterans and the large amount of money dispersed by the fiduciary program, the need for effective oversight is vitally important. Our recent reviews have found gaps in VBA's program management and internal oversight processes. These gaps have contributed to delays in determining whether a fiduciary is warranted, reimbursing veterans when their benefits have been misused, and issuing deceased veterans VA-derived funds to their heirs or back to VA. In addition to this oversight work, the OIG's Office of Investigations is involved in criminal cases to help deter and investigate fiduciary fraud to reduce its impact on victims. In a report released last month, we substantiated allegations that VA-derived funds were not always promptly dispersed to the deceased beneficiary's heirs or returned to VA. We focused on 2 fiduciaries who had not released the funds, with delays in distribution ranging from 19 months to 12 years. There is not a statute or VA regulation that sets a timeliness standard for disbursement. However, as stewards of taxpayer dollars, VA should be promptly reclaiming funds when there is no valid will or heir to receive them. Heirs also should not have to wait excessive periods to receive funds to which they are entitled. Although not statutorily required, VBA is not prohibited from verifying funds are dispersed to deceased beneficiaries' estates. Such verification would not only ensure heirs receive funds to which they are entitled, it would also help identify funds that must be returned to VA. The OIG made 3 recommendations to VBA to clarify their internal procedures, implement stronger electronic controls, and better track workload. These recommendations are not yet implemented, and we will monitor VBA's progress through the follow-up process. We also recommended VBA consider re-implementing the procedure to verify that funds are dispersed to veterans' heirs. VBA responded that they did not consider they did consider the recommendation, but do not intend to implement the change since there is no legal requirement to do so. We closed this recommendation because while we consider it a best practice, VBA is ultimately responsible for making this management decision. Our prior oversight also showed that insufficient monitoring and program management not only led to significant delays in essential fiduciary program processes, but also increased the risk that beneficiaries would be vulnerable to fraud, theft, or financial loss. In 2020, while assessing the merits of a fiduciary program hotline allegation, we discovered VBA had not finalized a veteran's incompetency proposal, despite receiving medical evidence that the veteran was incapable of managing their VA benefit payments. We expanded our review to identify broader process issues and found that over 4 years, VBA had not finalized incompetency proposal for over 200 beneficiaries. We provided VBA with these records so they could determine whether further action was needed. In a July 2021 report, we examined whether program staff properly addressed allegations of benefit payments being misused by fiduciaries and if VBA reimbursed beneficiaries as required. Our team found instances of significant wait times for staff to make determinations and reimbursements. For example, one beneficiary waited 19 months for staff to complete a negligence determination. VBA then reimbursed the beneficiary over $20,000. We concluded that VBA should consider whether the average number of days taken to complete each type of misuse action is acceptable. We also found VBA needed to better monitor all follow-up actions on reported misuse, as they were unaware of many of the unprocessed negligent determinations we identified. We made 2 recommendations to ensure prompt completion of determinations and reimbursements. In response, VBA implemented new technology that allowed for electronic monitoring of these processes. Both recommendations have been closed as implemented. OIG teams have found that the pension and fiduciary service should ensure effective program management and internal monitoring processes are in place. This, in turn, will help beneficiaries receive the program support to which they are entitled. The OIG is committed to continuing its oversight work of the fiduciary program and criminal investigations into potential fiduciary fraud that affects program beneficiaries and hinders the most effective use of taxpayer dollars. Mr. Chairman, this concludes my statement, and I would be happy to answer any questions you or other members of the subcommittee may have.
Thank you, Ms. Herron. The written statement of Ms. Herron will be entered into the hearing record. We will move on to questioning. I recognize myself for 5 minutes. Ms. Van Herron, is it true that VA does not monitor or track with any electronic controls whether a fiduciary returns the funds of a deceased beneficiary?
Yes, we found monitoring issues when it came to specific tracking of the dispersed funds to veterans' heirs. This was a best practice that we recommended that they implement or re-implement, and this was once a requirement.
But no longer?
No longer.
Mr. Friel, isn't the VA supposed to ensure that taxpayer dollars are going where they're supposed to go? And isn't VA a steward of taxpayer dollars? If that's the case, why doesn't the VA make sure that a fiduciary gives a deceased beneficiary funds to the veteran's heirs or back to the VA?
Thank you for that question. So as it relates to back to the VA, we do at notification of death, we will institute a requirement for a...
if you get a notification of death?
When we get notification of death.
What happens if you don't get a notification, which...
Well, typically, we have installed several different mechanisms within our systems to get the notifications of death. We have a direct feed from Social Security so that we get their indications of notices of death so we can activate them. We also work with VHA if the veteran would happen to die in a VA medical facility so we can activate it there. And we are constantly seeking other opportunities to get notifications of death. We are dependent upon third-party notification because it's not, we don't have the mechanism to be there all the time to see what is happening. So we also require, look to the fiduciary to provide us notice of death when the beneficiary passes away. So once we have the notice of death, we will determine whether or not we have heirs have been identified or if there's a will for the estate. In those circumstances, we have the fiduciary will establish a trust so that the funds are available basically on the decisions of the estate and whether there's a probate court involved and the decisions they made about how the funds should be distributed. If the funds need to be returned to VA, then we will work with the fiduciary to have those funds returned to VA.
Just so I understand, but that you do not track the program of work on notice of death?
We do track the program.
You do?
Yes, we do.
You 100% sure on that one, sir?
Yes, sir. As I said, we have mechanisms in place for notices of death, right? And so when we trigger when the first notice of death is triggered within our systems, whether it be we receive information from Social Security, whether we receive a call from a third party letting us know that the beneficiary is deceased, whether we receive something from VHA, we have numerous avenues we get notifications of a potential veteran's death. And we will then trigger that within our system. Within VBMS, what happens now is that creates a trigger to the Fiduciary Hub, and the Fiduciary Hub is given notification. They create a task to then determine whether or not an accounting needs to be done, and if we have information about to determine where the funds will go. If the funds are to achieve to the state, then VA will reclaim those funds. If the funds are to be distributed to an heir or have to go through probate court, that we have the fiduciary will establish a trust so that the funds will be available.
Okay.
I would say I'm sorry.
I'm tracking.
Okay.
Why aren't fiduciary cases in the national work queue for assignment and tracking? And I'll give you a little grace. The national work queue is, I won't say a dumpster fire, but it has its issues. But the amount of money that is going out the door from VA through our fiduciaries is substantial. I'm curious why it's not a part of the national work queue.
So So with the recent migration into VBMS, we've been in VBMS for about 2 years now. Prior to that, we had a beneficiary fiduciary field system, which didn't allow for us. It definitely restricted us on the data flow and the data sharing. Now that we're in VBMS, all the records are available. We are working with our NWQ partners as well as OINT to see about the potential to move the fiduciary workload into an NWQ type environment.
When you say see, what do you mean by that?
Excuse me?
You said we will see if we were able to do that. What does that mean?
Well, there are certain restrictions within the fiduciary program that would limit what we can do within NWQ. For example,
Is that legislation?
no, it's not, sir. It has to do with the way that the work is distributed within the field examiners, right? Field examiners are regional or have specific areas that they're responsible for. So the NWQ workload would not benefit. We distribute that workload via.
So fiduciaries can't go into national work queue because it's dispersed across the country and it needs to stay in one particular spot.
Right. We believe parts of it can, like the accounting pieces. We believe there's a potential for putting them into a national because we do not have a need to particularly go out to a beneficiary from the accounting perspective. But as far as the field exams, we are restricted in that, we have people assigned to take care of specific areas, so that work is distributed that way and can't be distributed nationally.
Okay, thank you. I now recognize the ranking member for 5 minutes of questioning.
Thank you, Mr. Chairman. Mr. Friel, I want to ask about the process of determining the most appropriate fiduciary for a beneficiary. And I recently heard from a constituent who had a relative pass away, and upon their passing, he learned that this family member had been already assigned a fiduciary. In this case, there was a power of attorney on file for the beneficiary, and yet when VA proposed to appoint a fiduciary for the beneficiary, the person with the power of attorney wasn't contacted or informed about the proposal to appoint a fiduciary, nor were they considered for this appointment. Instead, a private law firm was appointed without any notice to the family. So my question is, when there's a power of attorney on file for a beneficiary, is this considered, and to what extent is the Pension and Fiduciary Service required to consider a family member as a potential fiduciary when, when there's this power of attorney that already exists?
Yes, sir. So as it relates to the appointment of a fiduciary, upon the final decision of incompetency, we will initiate a field examination. And part of that field examination will be an individual from VA, a field examiner, going out and meeting with the beneficiary. One of the things that we strive to do is seek if the beneficiary has anyone that they would like appointed as the fiduciary. So we try to make that relationship happen first. So if there's a relationship that would work, we would do that. But in that, we also hold that fiduciary responsible to meeting the same requirements. So we do a criminal background investigation, we do a credit check to ensure that there would be nothing that would bar that individual from meeting the fiduciary. Sometimes, sir, we don't know what the family relationship is. If the family is not, they're not connected, and the beneficiary may not want to appoint one of their family members. In that case, where we cannot find somebody that has that type of relationship, we will seek to look at a professional fiduciary, where we will go out and we appoint some, like attorneys or some other organization or an individual who does multiple fiduciaries who's professional. In that space, when we have a professional fiduciary, we do limit them. Their fee can exceed more than 4% of the beneficiary's entitlement.
But just getting back to this specific case, and maybe we can follow up on some of the details, because I know you can't get specific here for this individual, but this was a veteran who had a family member as a power of attorney, and this individual wasn't even consulted or notified that the veteran was appointed a fiduciary. So there's no requirement to consider a close family member who has power of attorney.
To your point, sir, without knowing the specifics, because that power of attorney, if it's not designated in our system, we may not be aware of it, and it may not have been raised by the beneficiary that there was a power of attorney appointed outside of the VA space.
Yeah, I believe in this case it was on file, but we'll follow up with you on that, and I appreciate it. And so, Mr. Friel, in my opening, I mentioned being concerned about the authority that fiduciary staff have when it comes to monitoring beneficiaries. So the question is, how is VA empowering employees to ensure beneficiaries' well-being? And, if they determine that a once-yearly virtual visit isn't enough to protect a beneficiary, what other steps are taken?
So we have, within our purview, as I stated in my opening statement, we tried to increase our oversight while also in reducing our intrusiveness, into the beneficiary's life. We used to, if they wanted to give, previously, if a beneficiary wanted to give funds to a grandson or granddaughter for graduation from high school, they would have to clear it with VA, and we didn't think that was appropriate. If the funds are there and they have that ability, then we don't see a reason we should be that intrusive to say no. So what we have done is we've streamlined our processes somewhat. We have the video, the ability to do video, which we didn't have prior to COVID, but we give the leeway to the fiduciary hubs. If they feel that something is amiss and they should go out and do a field exam, they have the right to do that. We do not restrict that. But it's based off their decision. However, we do try to limit how much time we spend, intruding into a beneficiary's life.
So for our most vulnerable beneficiaries, those with severe mental illness, maybe those who may not be in a position to report suspected fraud or misuse, that's taken into account?
Yes, it is. We limit I believe you're referring to the annual written contact that we have, where we send a letter. That letter, though, is restricted, right? We do not open it up to the entire population. The only individuals who are open to receive that type of contact are where we have a spouse fiduciary who is appointed, and we have a good standing relationship. We have a custodial parent of a child who is a minor, or they are in a federal or state or federal institution, or they are in a VA institution where the government has oversight of that individual in that facility.
Okay, thank you for that. I yield back.
Thank you, Mr. Pappas. Mr. Self, you're now recognized for 5 minutes.
Thank you, Mr. Chairman. At your hubs, how many total employees do you have managing 108,000 beneficiaries?
Total is approximately 1,200.
1,200. And you just talked about intrusive. Fiduciary is financial, right? So is there not some way to audit this? Because this is elder and disabled, very open to abuse. Let's just face it, regardless of who the fiduciary is. This is a system that is open to abuse. So it looks to me like the audit, without being intrusive, I agree, you shouldn't be approving every spending line. But there's got to be an audit, and I'm getting to the point that almost every hearing we have with VA, we hear a lot of process. And there's a lot of process here, the way I understand it. But there's also people behind every process. So something that I didn't see in the notes that I was given is it says we were supposed to figure out how someone qualifies as a fiduciary, whether it be an individual or an entity. How do you qualify them?
So, sir, thank you for the question. We will first go out and, as I said, meet with the beneficiary and see if the beneficiary has someone they would like, right? Once we have that, what we look for qualifications is we do a criminal background check on every fiduciary before we appoint them. So we're looking to see if there's any triggers that would say this person should not be a fiduciary. We also do a credit check on them to see if they've had any credit history issues that would also say that they should not be a fiduciary. So that's up front. And once they are in place, we continue to monitor. If a beneficiary receives more than $10,000 a year in VA funds, the fiduciary is required to do an annual accounting, which means every 12 months they have to submit all the statements from us from the bank, as well as any big ticket receipts, and we will do an audit of that account. For those who don't meet that process, 3 years ago, we instituted the funds under management review. So in that period, what we do is we look at 3-month periods biannually for all fiduciaries to see and evaluate to make sure that they are spending the funds properly.
Okay, now it also says that the regional offices do not track all work through the national work queue. Does anyone?
So we are able to track the work. We do not use the national work queue for work distribution. Because of the way that the fiduciary hubs were established to be regional, we separate the work by zip code, basically, and the work is assigned to the fiduciary hubs based on the zip codes that they are responsible for. So the fiduciary hubs, as well as the Office of Field Operation, as the Office of Pension and Fiduciary Service, now have access, since we have moved into VBMS, we have access, more sufficient access to the data. We have better oversight of the workload and are able to monitor it in a much better way.
Is there some way to simplify this process?
Sorry, that's a good question. I think we are continuing to strive to look for opportunities to improve it. What we have done in the last couple of years with the move into VBMS, as well as the review and the streamlining of our oversight and adding the funds under management review, which didn't exist properly, adding the additional background check, or the background check for sitting fiduciaries, which had never happened before, are all things that we are looking to do to continue to provide oversight, improve our oversight, and ensure we're doing the right things.
Mr. Chairman, I think we need to, because this is a recurring theme, the complexity of the VA. Everything we hear is just the complexity. I think we ought to recommend somehow trying to figure out how we simplify this whole place. With that, I yield back.
Thank you, Mr. Duff. Mr. DeLuzio, you're recognized for 5 minutes, sir.
Mr. Chairman, thank you and good morning. Ms. Van Haren, start with you. What is your estimate of the percentage of fiduciaries who are committing fraud in the program?
I work for the Office of Audit and Evaluations. That is more of a question for our Office of Investigations that do that work and look into more of the fraud aspect of it. So I can take that question back and get back to you.
Thank you. Mr. Field, do you have a sense of what that number is?
So sir, we distinguish between fraud and misuse, right? So we in Pension Fiduciary Service, we determine fraud that's an IG investigation because that's more of a legal determination. We look into misuse as where the funds for the beneficiary are not being used specifically for the beneficiary. I can tell you so far, as of August 30th in 2023, we've had 1,164 allegations. Of those, we've only found 167 cases where misuse actually occurred. So we continue to monitor that, and the misuse allegations can come from anyone, and as well as from the oversight that we provide.
So 168, I mean, we're talking sub 1%.
Less than 1%, yes,
Okay.
sir.
Do you think that actually I'll ask Ms. Haren first. Is VA's oversight here, whether it can be improved or not, I think we suspect here it can be improved, but do you think it is part of keeping that number as low as it is at the moment?
Sure. Based on what we found in our targeted reviews that we've done, we found program deficiencies with internal oversight. I think it's a continued, theme that, we've seen. But I think it's something that, can continually be improved with, monitoring of programs and so forth, procedures.
Mr. Friel, if we head to a government shutdown on October 1st, how will that impact your ability to conduct oversight here?
So if we stay to the same matter that we did with the last shutdown, the field individuals, employees responsible for claims and that oversight at that level will continue to work. They will continue to provide the oversight and the claims processing that we have to do, right, to meet the needs of the veterans. The oversight as far as, the central office may be minimized somewhat due to staffing because we're not considered the essential part of actually producing claims and providing that level of oversight. But we will have the opportunity to work with the field and monitor the field as far as what is happening and making sure the right things continue to happen even during the shutdown.
So at a minimum, you're expecting some of leadership and central oversight to diminish if we're shut down?
As a minimum, yes, sir.
And do you think that will impact the ability to find misuse or fraud allegations?
I do not, sir, because typically that misuse allegations and that finding happens at the field level, right? It's our 1,200 employees who are engaged within the fiduciary hubs who are out there doing the work every day. Those are typically the individuals who identify that. So even in cases where we have the IG fraud and the investigation, the majority of those are triggered by the field identifying that there was in fact misuse and then forwarding that information to OIG so that they can take action.
So I guess walk me through then what the impact of the folks you've just described who will be impacted or won't be considered essential. What's their role in this oversight process and machinery? So
within the central office function, we are required, we have the responsibility for providing quality oversight, so we do quality reviews on the work that happens at a national level. We also do special focused reviews to look at specific areas within programs to identify if there's any deficiencies in there and or opportunities for improvements. As well as we do site visits, so we go out to the field and we will visit the office.
Okay, let me ask then, I see. So would the lack of quality reviews, do you think, impact the effectiveness of your program?
I do not. This year, the fiduciary hubs are performing at the exceptional level for their quality, and I don't see any reason why that would not be maintained. So
Ms. Herron, do you have the same view? Ms.
can't-
Van Herron, excuse me.
That's okay. I can't speak to the quality review percentage at this time, but I think it's important that they continue to monitor this type of work.
Would you recommend eliminating the quality review and the central office functions that would be impacted during a shutdown in general? Would you ever recommend removing those folks?
We have not done any work in that area, and I can't speak to that.
Okay. Thank you. Mr. Chairman, I yield back.
Thank you, Mr. DeLuzio. Ms. Ramirez, you're now recognized for 5 minutes.
Thank you, Chairman Luttrell. I want to thank the witnesses for joining us today as well. We've been talking about fraud and how do we make sure the beneficiaries are actually getting their funds. I may have missed this question, but I want to just jump into some of the questions I have around that, and then I want to move into the dependence of the beneficiaries. Mr. Friel, how long does it currently take the VA to recoup stolen benefits and return them to the veteran who's rightfully entitled to them?
Thank you for that question. So the recoupment of the benefits is not a key factor in making the beneficiary whole. We are able to make the beneficiary whole once we have finished the misuse determination and determined how much funds were misused, and we have an internal negligence determination requirement that we have to meet. Once those two items are in place and we have completed them and the review's done, typically we initiate trigger to the field to submit to reimburse those funds within 14 days of the final.
So about 14 days, once that's happened?
Yes.
But how long on an average is it taking?
So currently, from misuse allegation to determination is about 80 days. The turnaround time for the negligence determination is probably another 10 days or more. So
It could be up to about 90 days?
it could be, yes.
Okay. So I want to, in the state legislature, I chaired the Child Welfare Committee. And as we're talking about the beneficiaries, one of the things that comes to mind for me is also its own dependence. As we're discussing this issue, I want to talk about the children impacted by fraud. Specifically, I'm concerned with foster youth. It's come to my attention that this committee asked the VA in 2022 how they were tracking vulnerable population, and the answer was, and I quote, "The VA does not currently track the number of children in foster care, and so it's not aware of any data points that would allow for an accurate estimation of this number." Here's why that's concerning to me. I'm concerned for children, especially young children, who are unlikely to detect and report fraudulent behavior. So question, Mr. Friel, can you tell me how the VA tracks which dependents of veterans are in foster care? And if you do not, what are your next steps to ensure that this population is being tracked and protected?
Currently, we do not have the ability to distinguish what the current status of the child is. We do, however, appoint a fiduciary for those individuals in foster care that we monitor with all of our, as we would with any other fiduciary. I will let you know that we have had internal discussions and we are working towards a requirement for our Office of Information Technology to actually identify an opportunity within our system to be able to add that as a field that where we can track that in a better manner.
So in my state of Illinois, there are children of deceased veterans who are currently in foster care, and they're receiving benefits. I know this because we checked in with the Illinois Department of Children and Family Services, and they confirmed that they produce and submit a quarterly report on the children to the VA. So my question to you is, Mr. Friel, as you are discussing internally how you're able to better understand and track that information, what are you doing with the data from states like Illinois who are providing this information? And I know that it may not be the case that every single state is providing this information, but I am interested in knowing what you're actually doing with the information you are receiving from states like Illinois.
Yes, ma'am. I don't have that information readily available. I believe it's probably a factor that they work with the Fiduciary Hub within their space. But I will take that back, and we will work to get you an answer.
Yeah, so Chairman, I just want to put this on the record, and I appreciate that. You know, as we're talking about our beneficiaries and the fraudulent behavior that we see from many of these fiduciaries, I am concerned by the number of veterans, particularly as we talk about veterans who are experiencing homelessness or veterans who have passed away and their children in foster care, that the various agencies that are supposed to be their fiduciary or manage their benefits, or the fiduciary person responsible for their benefits, in fact, may be engaging in fraudulent behavior, and these children are not getting their benefits. So I do want to make sure that we continue to follow up on this, because there are a number of children who I'm concerned have no process in making sure that these allegations are followed up with. With that, I yield back.
Thank you, Ms. Ramirez. Mr. McGarvey, you're recognized for 5 minutes, sir.
Thank you, Mr. Chairman. Thank you all very much for being here. As you know, my district in Louisville, Kentucky is home to one of the VBA's 7 fiduciary hubs. It services 6 states along with DC and Puerto Rico. The Louisville hub, like each of the fiduciary hubs, is responsible for handling oversight of the fiduciaries in those states and administering the program. The hub's dedicated public servants are doing their best to ensure that veterans and their benefits are protected. So I want to thank them for their service. And as you know and see in this committee, this is something we all want to do and all want to protect, is make sure our veterans get their benefits they've earned and they deserve. But I do want to note that they need funding, they need resources to carry out their mission, and ensure that our veterans are not being defrauded and that the fiduciary program is working as it is intended. Mr. Friel, how does the VBA monitor fiduciaries, and what does the oversight look like? And I guess the big question is it enough?
Thank you for that. So in monitoring, we use several mechanisms. We do, for fiduciary, as I stated earlier, has a beneficiary that receives over $10,000 a year in benefits from VBA, or they're rated 100%. We will require an annual accounting from that fiduciary so that we can audit and make sure that the expenditures are being made correctly. For those who don't meet that criteria, we also have the biannual review, where we do an audit of 3 months worth of benefits every 2 years to ensure that those are, in fact, their benefits are being used properly. We also have the ability to react to any instances where we someone provides information that there may be an allegation of misuse. The field examiners have the ability to go out and investigate and to ensure that everything is happening correctly. Additionally, we instituted, back in 2020, we instituted a standing background check for all sitting fiduciaries. Prior to that, once you were appointed, until somebody told us something we didn't know. Well, now we run a background check on every fiduciary, and this year we identified 958 fiduciaries that were flagged, that had, under previous checks or at appointment, didn't have any indicators. Well, they've been flagged, and we're working now to replace them because we have information that says they should not be sitting in that position as a fiduciary.
And I appreciate that. And you talk about 2020, though. We do know that in the OIG reports, there were deficiencies found in both 2021 and 2023, showing that the fiduciary program is susceptible to abuse. And so the steps you've outlined, are these some of the steps that you've taken to fix some of those specific issues in those reports? And if so, what more can you do? How can you take the lessons that have been learned into the future and do better?
So our goal is to be 100% oversight and 100% ensuring the security of our beneficiaries. But we know there's bad actors out there. So we've instituted that. The move to VBMS has allowed us to provide better oversight. I will call into reference that, in particular, the IG report that indicated the funds sat there. Those funds were all prior to our move into VBMS, right? So we now have better oversight. But on top of that, even if we go back how long it took us, the fiduciary was aware of the responsibilities. Those funds were available when we reached out to see where they were at, and we were able to recoup or distribute those funds as appropriate, when the IG brought it to our attention. But so our fiduciary program, as far as the appointment and the directions and the understanding of the fiduciary responsibilities, is evident there that they knew what they were supposed to do with the funds.
And so I guess the question is, because what you see is we're all on the same team, right? We want our veterans to get the care they deserve. So just tell us in the remaining time, Are there additional resources or support from Congress that are necessary to protect beneficiary funds and prevent future misuse? And what changes do you recommend? How can we be of better help?
Yes, sir. We would appreciate support for Representative Connolly's bill, HR, I think it's HR 4106. That bill would fix an issue that was created by the Isaac and Roe Act. Basically, when they allowed us to make all fiduciaries whole, which is something that we wanted, all beneficiaries whole, excuse me, which is something that we had been wanting to do prior to that act, we could make certain beneficiaries whole, and other beneficiaries was dependent on the negligence requirement. But that act allowed us to make all beneficiaries whole. What it did, though, is it actually slowed down our process, because now it mandated that we do a negligence determination for every claim or every misuse that occurs, which has no impact on the funds that are going to be dispersed to the beneficiary. With the proposed bill, it would push the responsibility of the negligence determination down to the field, which would basically allow them to more quickly get those benefits out, and it would make the oversight of that, it would make it at the pension and fiduciary level. At the national level, it would be more of an oversight feature than an actual having us make the determination.
Thank you, Mr. Chairman. I yield back.
Thank you, Mr. McGrath. We're going to move into our second round of questioning at this time. Mr. Friel, do you have a rough guesstimate on the dollar amount, let's just say the last 2 years that have been lost in the fiduciary program?
So this year, I do have the data for this year. This year, to date, as I said, we found 167 misuse cases, and the funds that have been reissued was just in excess of $618 million, or excuse me, $618,000.
$618,000 just this year?
Just this year, sir.
Okay. Is it true that fiduciaries must only account for 3 months of expenses every 2 years?
Not all fiduciaries, sir. It's only fiduciaries where they don't meet the threshold for the requirement to report annually. So if the funds under management, the funds that they are being dispersed every yearly for the veteran exceed, or the beneficiary exceed $10,000, or the veteran is rated 100%, they are required to report annually. Outside of that, we previously had no accounting requirement. One of the things that we instituted was the three months fund under management review. That happens biannually, so that we can continue to evaluate those individuals to make sure those funds are being spent properly.
And that's individuals in those particular areas going out to speak directly with the fiduciary, or is it a letter, an email? How are we tracking that?
They actually are required. We will trigger a letter to the fiduciary letting them know they are responsible to provide an accounting. We will then we let them know that accounting needs to include the last 3 months of bank statements, as well as receipts for any big ticket items, and we will evaluate those bank statements to see if there's anything that we see in there that shouldn't have occurred, and then we will work with the fiduciary to figure out how it happened and why it happened.
Ms. Van Haren, in your opening statement, you had three ideas you wanted to pass off to the VA that might help increase the loss of not only money but responsibilities for the fiduciaries. Can you tell me those three again?
Sure. The recommendations were to update the procedural requirements to help verify funds for dispersing, to help staff verify funds for those that are dispersed to heirs or back to the regional office, or excuse me, back to the regional office. Another one was to establish electronic controls to monitor that workload. They had a system in place, but they were unable to consistently find or be able to track that type of workload in those funds, whether they're being back to VA or to the heirs. And lastly, it was to determine the methodology on how they plan to monitor.
How long ago was that report given to Veterans Affairs?
The report was published in August of 2023, and we have a robust follow-up process. About 90 days from when it's published, we will reach back out to VA. And
How far along are you, Mr. Friel, on engaging those?
So we have started to look at those.
What does that mean, started to look at?
So we are working on, so some of it is an IT solution, so we are working on developing the requirements and system to get the system enhancements and get it scoped.
I don't know if I'm necessarily going to allow you to tuck that into the IT space.
I'm not pushing an IT space. I'm just, for us to do there as far as like to being able to track the workload. Today, as far as the first notice of death, the way it's triggered to the Fiduciary Hub, we want to create an end product, a work item, so that they can actually go do that as opposed to a task. So we're working with IT to make that happen in the system. So we would change the system, enhance the system to give us better oversight and tracking of those through the end product.
And the other two?
The other two, I'm sorry, the one was the air, which we had spoke about earlier, was distributing to the heirs, and we have worked with the Office of General Counsel. We've received OGC opinion that it's not within our purview to make sure that the estate and the will and whatever decisions are made in the probate court are within our purview. They're not part of VA's oversight. Our oversight is will the funds escaped to the state, and if so, then we need to ensure they come back to VA.
So there's a point of convergence right there where VA is going to have to pass it off to the state, and the state's going to look to the VA to solve the problems?
So it's and not so much convergence, it's the laws of the state. Yes, sir, I guess, yes, you're correct, sir. The laws of the state, as far as if there's an error or if there's a will or probate, how that money will be dispersed to the family members is not within our purview. However, if there are no will or error, then we look to make sure that the funds come back to VA.
Okay. Thank you, sir. Mr. Pappas, do you have anything?
Sure, maybe a quick one for Mr. Friel. You were talking about some prospective legislation that could help the department with making determinations out in the field. I just want to ask you a bit about deceased beneficiaries, and you can have a beneficiary who passes away whose funds must be distributed to their estate or returned to VA. You can also have a veteran who passes away while a claim of fraud or misuse is still being adjudicated. So just to understand a little bit about how things work now, for that first population, a beneficiary who passes away while part of the fiduciary program, how does VA currently determine the order of priority for dispersing benefits to estate or to a deceased, to the estate of a deceased beneficiary?
So as it relates to the disbursement to the estate, we would go into trust until either the fiduciary would put the funds into trust until either the will is determined or the probate court acts to make determination on how the funds would be distributed. VA does not have any role in that, other than other than the fiduciary putting the funds into some type of trust. As far as if the funds would go back to the state, right? So if there are no heirs, there is no will, then VA assumes those funds, and we have the fiduciary return them to us.
And so just thinking about what steps you can take to ensure that sufficient guidance for Fiduciary Hub staff is in place to determine whether VA-derived funds of deceased beneficiaries need to be returned to VA. Any thoughts there?
So we do have currently within our requirement with the field exam, we try to identify if there's an error or a will during that initial field exam process. We are now working on actually in a system enhancement to be able to trigger that within the system too, so that we have that identification and we can utilize that data to kind of push out to let them know that, hey, we have information on an error or a potential will, and so that we can utilize our systems to let the fiduciary know that there is, in fact, someone out there that exists that the funds could be dispersed.
Okay, and if a beneficiary passes away where there's suspected fraud or misuse, can you talk about the authority that VA has to reimburse the estate of the beneficiary as the fraud claim is being processed? Do you have that authority? And
Yes.
If not, what do you need?
Today, we currently, if there's a misuse pending at the time of death, we will process that misuse to fruition, and we will make the estate whole as part of our process.
Okay. Well, I appreciate that. Thank you very much for those comments.
Thank you.
Yes, thank you, Mr. Pappas. Mr. Self, you're recognized, sir. 5 minutes.
Thank you, Mr. Chairman. I don't have the figure in front of me. I'm trying to get it, but if I remember right, there are like 8,000 GAO recommendations that the VA, across the VA, has not enacted. Can you tell me how many GAO recommendations that this program has outstanding?
Sir, I do not have that information available. We can take that back and delve into to see if we can identify any.
I would like to see it. I understand your current yearly, you haven't had time to close, but I believe that there are outstanding GAO recommendations from years past, and I'd kind of like to know that number.
Yes, sir.
With that, Mr. Chairman, I yield back.
Thank you, Mr. Self. Mr. Ziscomani, you're now recognized for 5 minutes, sir.
Thank you, my friend. Thank you, Chairman and friend, for holding this important hearing, and thank you also to the witnesses for being here today. One of the issues I've heard about facing veteran relates to the Veterans Benefit Administration Fiduciary Program. I know we've talked a little bit about that, and the instances in which an appointed fiduciary misuses the veterans' funds. While I'm sure that many of these VA-appointed fiduciaries are working hard to manage veterans' benefits, some bad actors exist, like in anything else in this program, that allow for fraud and misuse. I'm proud to have joined Representative Trone in introducing the Restoring Benefits and Defrauded Veterans Act, which would ensure the families and beneficiaries of a deceased veteran in the fiduciary program are able to be reimbursed for the amount of misused funds as well. Also, I co-led a bill with Representative Connolly titled the Veteran Fraud Reimbursement Act, which would allow veterans who fall victim to fraud to receive their reimbursements before the VA's internal negligence determinations is finished. I believe these common sense bills can ensure veterans and their families are financially made whole, and I look forward to working with my colleagues on the issue and continue to support the men and women who serve this great country. Now, my question is for Ms. Van Haren here. Is it true that the VA has no timeliness standard for determining whether a fiduciary's misuse of funds was actually the result of VA negligence?
Yes, at the time of our report, we found that there were no timeliness standards.
How has this resulted in delays in removing the fiduciaries and reimbursing misused funds? How does that impact that?
Sure. Based on the time that we conducted our review in the hotline, there was a significant amount of time before veterans were made whole from when the misuse determination or the allegation was made through the entire process, and the negligence determination was finally made. It was over 400 days at the time.
And what best practices would you say has the OIG recommended for the VA to ensure that we're effectively monitoring and tracking the VA's misuses of determinations of the reimbursement of the funds?
We recommended that VBA put in measures to controls again, and also monitoring procedures to follow up specifically on negligence determinations and reimbursements.
Would you mind naming a few examples of that, of what it can look like and how it can be improved?
VBA, at the time we conducted the review, VBA was in the process of moving from one system to another that was able to actually have reports made that they could actually track some of the negligence determinations that was once tracked on, let's say, outside of a system. So they didn't even have the information within a system at the time until they migrated into VBMS FID. So when they migrated into that system, they were able to then track it electronically and then, of course, monitor that work.
Thank you. Mr. Friel, on the same light of the timeliness of these services, from the 2021 Inspector General report on the Fiduciary Program, it states that, quote, staff took from about 3 to 23 months to complete the 14 negligence determinations with an average of 468 days, to your point as well. Half the cases were pending in excess of 500 days before being completed. The remaining 2 were not completed due to active criminal investigations, end quote. I've learned that processes have changed, but I believe that these negligence determinations are still taking way too long, to also the previous point here. What's the average wait time, you would say, currently for the negligence determination to be made, and what steps has the pension, specifically in the Pensions and Fiduciary Service, taken to reform this process? So same line of questioning here, but can you speak from your perspective on this?
Yes, as far as the negligence determinations, we are completing them I think in an average of like 24 days. I'd have to get you the exact number. But
okay.
we, as Ms. Farner spoke, we moved into VBMS, which definitely improved our ability and our oversight to be able to track this work and be able to manage it in a much better base, much quicker and faster basis. So the allegation from misuse to the determination completion takes about 79 days. That is the investigative part to determine whether or not there was actually misuse, and then it's working with the fiduciary to get the final accountings. I can tell you that we do have a standard for replacement of a fiduciary once misuse has been determined. If we determine that misuse did occur, we replace that fiduciary within 60 days of that happening. And that's one of our traction.
Thank you. I'm out of time, but would you agree that moving these determinations to after reimbursements would ensure veterans are made financially whole while still allowing the VBA to determine if negligence happened?
Yes, I would, because the negligence determination has no impact on the amount of funds that are going to be distributed.
Excellent. Thank you. And I appreciate the quick, straightforward responses from both of you. We don't always get that, but I appreciated that. Thank you.
Thank you, Mr. Subcommittee. Okay. Thank you to all our witnesses for testifying before us today about this important issue. The fiduciary program is responsible for ensuring that the veterans who need extra help managing their VA benefits are taken care of. It is our responsibility as Congress to ensure that the VA effectively oversees fiduciary and protects beneficiaries of this program. One veteran or beneficiary whose benefits are being misused is one too many. I look forward to further conversations about improving the oversight efforts of this program and about VA's efforts to implement the recommendations that we discussed today. With that, I yield to the ranking member for closing remarks.
Well, thank you, Mr. Chairman. I look forward to working with you to ensure the continued oversight over this program, which is incredibly important for veterans and their families. And I think it's important that our staff works together to ensure that OIG's recommendations are fully implemented by VA and that we see some areas of improvement that were identified in the hearing today. So our veterans deserve the best, and I know we can work together to help get it done. And I want to thank our panel for their comments and their work. I yield back.
Thank you, Mr. Pappas. Mr. Friel and Ms. Van Haren, thank you for your testimonies today. I don't envy the pressures that you're feeling on your shoulders, sir. I can only imagine how overwhelming that is. But please understand that this committee is absolutely here to assist you in any way that we can to make sure the veterans are the beneficiaries of all of our acts, everything that we do. Ms. Van Haren, thank you for your report. If you don't mind, I'd like to speak to you after the committee closes out. I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include extraneous material without objection. So ordered. The hearing is adjourned.